the topic today that I really want to cover is all about unrepresented buyers. I think this is a very relevant topic. With everything going on in the media across the nation, we are getting hit with that. In my meetings last week, we were talking about this topic. And it's funny because as Shannon and I were preparing what topic we wanted to talk about tonight, I said, let's do unrepresented buyers, essentially talk about representation and what paperwork we need in Washington for these types of things. And we went back to look and see what we had. And it was funny, the last year, about the same time, we also covered this topic. So you'll see that there has been some changes, but really, for the most part, we are going to be going over the forms that are related to these types of situations. So if you do want to take notes, we are going to go through the paperwork in its entirety today for some of these forms that are needed. So let's go to the next slide. So the news article this morning, I woke up, checked my email as I do, and going through it. And Inman News, I do subscribe to the Inman News. Sometimes I wonder why I subscribe to some of these media channels, but I do. And I do pick up a few tips and tricks, but also they're talking about it in their media channel as well. Agents brace for impact, the future with more unrepresented buyers. So I was like, wow, if I wasn't already thinking about unrepresented buyers last week, the media is definitely going to be wanting us to consider these types of situations. So article was written, basically the theme of the hour or the theme of this article was all about how one broker took advantage of the situation and utilized the forms in such a way where he was able to make a business off of unrepresented buyers. So essentially he represented the seller and was able to make a lot of money by not representing buyers at all. And obviously there was some logistics around how to make that happen. So you may be experiencing this. You might be getting a lot of uncertainty. We'll kind of go over a few. We have 3 scenarios to go over tonight. But I thought it was interesting that they're talking about this, the do-it-yourself model. It's not like we haven't talked about this since I got licensed back in the early 2000s. So it's something that you want to consider. These different business models might spring up. You do want to be prepared to know what forms to use so that you can talk openly about this type of situation. So here are the 3 scenarios we're going to cover tonight. It's like a kind of a conversation about wholesale versus retail. We've talked about that in prior trainings, but I want to talk specifically about these 3 situations. Number 1, the buyer does not want representation. Essentially, the buyer says, I don't want to sign the buyer service agreement. I don't want to have representation, but I am interested in this property that you are listing or that you are representing the seller on. So how do we deal with that type of situation? That's number 1. Second one that I want to cover tonight is sale to an identified buyer. The seller wants you to represent them, but they have found the neighbor. Maybe they found a friend, and obviously they want to cut out the buyer compensation and just have you write and represent the seller only. There is those types of scenarios that are popping up. In fact, I dealt with 2 over the weekend that you guys called me about. So definitely want to cover that as well. The third scenario would be the property owner does not want to list, but is willing to pay a buyer compensation. Essentially, that's a for sale by owner. And some of you are actually calling for sell by owners, which is very smart, very strategic to do right now because of all of the media craziness. Some of the property owners are wanting to try and do this themselves. And there is a slew of buyers that are waiting on the sidelines looking for these opportunities. So you may want to entertain that third option if you're looking for business. So I want to make sure we have time to cover all 3 scenarios with the paperwork. So before we cover those scenarios, I think this is an underused form or an underused addendum. When I am practicing real estate in all 3 of those scenarios, I will always, always, always use a Form 22RA. And the reason for that is it's proactive. It's a proactive addendum that allows me to represent either the buyer or the seller, or even in some circumstances, I might represent both parties, but it puts the buyer or the seller on notice and allows them to get an attorney to look over the paperwork. In the cases of an unrepresented buyer, specifically in that scenario, this is super essential. I may not have number 2 checked where the seller has an attorney review, but I'm allowing that buyer to have their attorney review the purchase and sale agreement. So I might create everything, I represent the seller, but then the buyer has 5 days. You can certainly cut that down if the seller, wants to put the paperwork together. But at least I've provided a vehicle or a way for that buyer to go ahead and get themselves in touch with an attorney to look over the paperwork. Certainly is going to be at their cost, certainly is, circumstances like that, but it definitely has saved me a ton of legal time by using that addendum. So what could potentially happen, just so you guys understand, is you don't use a 22 RA, and then the buyer, you write the deal up and you represent the seller, the buyer has no representation. And then what happens is the buyer gets under contract and we're a week away from closing. And the buyer says, I was not properly informed. I was not legally, they put something in front of me and I was basically harmed. There are more chances for a lawsuit to form without the 22 RA when you're dealing with an unrepresented buyer. So it's always best practice to use that 22 RA. So here's what number one scenario we want to talk about was the buyer broker service agreement. I have the first page here on the screen so you can reference this as we're talking about the scenario, but I'm hearing from some of you, not everybody, a lot of you have taken heart in how you explain this agreement after we've trained this multiple times, but the buyer still may say no. They do not want to sign the agreement. They do not want to enter into, they essentially want to do their paperwork on their own. They want to represent themselves. So it would be like if you were going to attempt to represent a client in a court of law and the buyer's like, I think I know more and I want to do it myself. So in that case, you have an option. You might want to revisit just one more time and see if they would be open to signing a non-exclusive with you. At least you get something signed by this client in case you came into an agreement. And it could be a non-exclusive where the seller then is paying your compensation. A non-exclusive would comply with the state law of having a buyer broker service agreement. If we are collecting some sort of buyer compensation, we need to have something in writing that allows us to collect that amount. But if they say no and they will not sign this agreement whatsoever, then you need to use a 22 RA if you are writing up the purchase and sale agreement, and you will only be able to obtain compensation from the seller, not from the buyer. So they are not agreeing to pay this. Let's go to the next slide. So number two scenario would be a sale to an identified buyer. Now in this circumstance, this would be if the seller was, you were representing the seller, but they found the buyer and they were like, Rochelle, we want you to represent us, but we want to sell it to the neighbor next door. In this case, you would still use you could use a listing agreement. That could be done as well if they want to open the marketplace up so they could really market and showcase it to the bulk of the marketplace. When you're using a Form 47, I always highlight term 7 right there. Shannon, if you can just put a little marker on that. No marketing and fair market value. I actually take a highlighter and highlight number 7 because I want that seller to be very, very keen and read that section, because it says the seller acknowledges that the firm will not market the property on the multiple listing service, even though the exposure through the open market may get them an increase or the likelihood of making more money or more exposure for their property. And they're choosing not to by going and selling it to the neighbor, for example, like we're talking about tonight. In this case, we would use a Form 47. We would identify the buyer. We put that we have to specify who that buyer will be. And then we will use a purchase and sale agreement. And we will, of course, include a 22 RA because we are going to be representing the seller only, not representing the buyer. We are writing it up for a buyer that's unrepresented. And then once we close escrow, Northwest MLS will require us to report the sale, and we will remind you in the office to do so, but it is something that you want to keep in mind. The sale will be reported, and it does impact sometimes, depending on the sales volume that would happen in that respective city or area. Let's go to number 3. The third scenario would be a for sale by owner. This is where you don't represent the seller. The seller has their own representation. They're going to represent themselves. But the buyer, you will have probably put a buyer service agreement in front of that buyer before you write the deal. In fact, you will. That's a rule now. And then you would put a purchase and sale agreement together, and you would use a 41C, a 22 FSBO, and a 22 RA. And you would have all of those forms available so that you can negotiate your compensation. The 41C is used to negotiate your compensation when there is no agreement, when there's no compensation offered by the seller. You can certainly check the box on the first one. Or you can offer a credit or a reduction. There are different options. Most of the common for sell by owners that we see, they check the first box right here, and they indicate there's no offer of compensation. They check that box, but then the seller is offering to pay what at closing. So essentially 41C would be used, and then they would check the other box on the first page of the purchase and sale agreement to negotiate their compensation, as far as a seller paying a portion or all of the compensation that you have already obtained consent from the buyer on the buyer service agreement. So that is also done with a for sale by owner. You use a 41C and use a 22 RA. You'll use a 22 RA in all three scenarios. That is the best way to protect you and to protect the firm from further litigation that would come upon us. Okay, let's go to the next slide. So purchase and sale agreement, when it's an unidentified or an identified buyer, or when it's an unrepresented buyer, the MLS number would not exist in the instances where there would not be a listing, where we're dealing with a purchase and sale agreement. So that can just be, I usually see lines, or I put NA. That is also very common to see that on the MLS number. Number 16, that's where you would identify the representation. So in the case of number 1, where it's a the buyer says, no, I just want to represent myself, you would check the unrepresented buyer, buyer represented by, unrepresented, that box would get checked. Seller represented by, listing broker, that would be you. And then number 17, you would check the other box. And then the addenda, you would include the 22 RA. So that's the kind of forms that you would use in scenario number 1. Scenario number 2 would be, remind me again, Shannon. See, I gotta go forward here. Scenario number 2 is what?
Sell to identified buyer.
Identified buyer, right. Okay, so that one, same thing, sell to identified buyer. The MLS number, most likely, actually, we wouldn't be putting it on the market because it would be to an identified buyer, so there's no MLS number. Same process, you would X that out, or you put not applicable on MLS number. Number 16, sale identified to the buyer. Now, if you were not representing the buyer, you're only representing the seller, and I would recommend that to on the Form 47 to only represent the seller, especially right now when everything is going crazy. Same thing, unrepresented would get checked, seller represented by the listing broker, and then you check the other box, and you would include, if you were having to include the 20, again, there's compensation. Other addendum would be how you get paid for the seller. So you would include the other C addendum. Form 47 would be what you would include so that the seller and the escrow company can get you paid for the seller representation compensation. Addenda also, with scenario number 2, you want to use the 22 RA. Okay, the third scenario, pretty simple, same thing, MLS number. Again, this would be, we don't represent the seller, so there would not be an MLS number, or there could be, depending on the situation, but we have to negotiate our compensation because it may not be on the market. In that case, we represent the buyer, the seller is unrepresented in that case, and then the number 17, other addenda, and you're going to need more addenda. You will definitely need the 41C. You will definitely want the 22 RA in the addenda line. At any point in time when you're dealing with scenario 1, 2, or 3, just be sure that all of the customers or the people that are not being represented, that they have a copy of that real estate brokerage in Washington pamphlet. It really answers the questions that they may have on who represents me, what is a dual situation. It explains it much, much better than it used to in the past. I'm actually quite pleased with how they've used language that consumers understand, and they've shortened that document from, I think, 6 pages now down to 4. Much, much better as far as a pamphlet. In Idaho, we also have a pamphlet that we have to use, and in Washington, same thing. So really, you just have to make sure you're using the proper state identified pamphlet, and get that over to the respective party. So for example, if I was not representing the buyer and I was only representing the seller, I still may go ahead when I send over the paperwork for them to consider. I will also send them over a copy of the real estate brokerage in Washington pamphlet that further explains. That way, if they decide during that attorney review that they want to go ahead and get themselves representation, they have the ability to do that. And that will give them an opportunity to read through the documents that every consumer in Washington should be aware of and know what their rights are. So keep in mind in Washington, if you simply write the purchase and sale agreement without providing additional real estate brokerage services, it's illegal. It's unauthorized practice of law, and it could lead to a variety of consequences that you don't want to be involved in. It's one of the common things that we see when we have cases go to court, is really when it comes to illegal practices that we are putting forth, such as I've indicated that I'm representing the seller, but then it's not quite clear that I represent the buyer. Even though my purchase and sale agreement might be clear, I may be putting paperwork in front of somebody and not giving proper advice as far as my legal authority to do so. In Idaho, customers are different than clients, but both need disclosures. So you need to make sure that you're providing those disclosures to both customers and clients. In fact, the blue book, the blue pamphlet that's required in Idaho, must be given right away before you put a purchase and sale agreement in place. So we've been already doing that in Idaho, and Washington now is just doing a lot more disclosure and a bit more clarity when they're doing those disclosures than they have in the past.
It's almost like we need to call it the green brochure now.
I know. Okay, green and blue. Okay, let's go to the next one. So I was, as many of you know, I'm on the board of directors for the Northwest MLS, and one of the common fines that were coming up, in fact, over a dozen complaints were filed. And this is other brokers in our area filing complaints on another brokerage or another broker. And on every single case that was filed for violation of Rule 2C, every single one was a fine. And that was really sad because some of these it was their first offense. Many of them were their first offense and they just didn't know, or they were getting pressure from their sellers to promote their listing or that opportunity. And I've seen a few close calls in our office. And I want you to be very, very careful if you go outside of our BCR connections or you go outside to other Facebook. That was probably the common theme, is they were promoting a listing before it was on the market, before the listing date on Facebook, saying I have a listing coming up or I have a staging picture. And so it's very clear, and it was things that were kind of harmless, but it's a violation of the Rule 2C that says that we're prohibited in Northwest MLS territory, but not limited to yard signs, flyers, websites. That would include all social media channels, emails, texts, mailers. I received a text message from one of our agents today that would, if I wanted to turn us in, I could turn us in, and we violated 2C. So certainly you want to be careful if you're getting that word out to other brokerages. They are out trolling for violations on Rule 2C, and every single one of them that I had to, it was unanimous. Everybody is turning people in for 2C, especially since our Northwest MLS is unique in the sense that we are owned and operate independent from the Realtor Association. And so if we're going to really operate across the state of Washington, I've got to get you guys over there in the Spokane region to agree with the philosophy of not doing coming soon. I would love to promote the listings in Spokane also on Northwest MLS, and I think I have a way to do that, but I need to get you guys all on board with that Rule 2C, that we are not violating that Rule 2C. So let's make sure that we have, if you have questions about Rule 2C, I'd love to hear about it. If you're questioning whether I should post this on social media ahead of the listing date, run it past me first. I will be the one to kind of say, yeah, that's not going to work. We don't want you to get fined, and we don't want you to get out the gate trying to do a good thing and it ends up backfiring on you or the firm. You certainly, if sellers are like, hey, Shannon, we want to promote this. We want to get the word out about this. But I don't want my, I don't want my home listed. I kind of want to just do an off-market kind of thing. There are ways of making their listing confidential. In fact, I've done that for a doctor before. I didn't even put the address on. I was able to list it on the Northwest MLS without the address, without a key box, without having appointments. I was able to sell that piece of real estate with just photos and essentially mapping out, not providing an address. So there are ways of exposing the property or the listing that you have by still maintaining some of these things that sellers will come to you and say, Rochelle, we just want to do off market because we are concerned about confidentiality, security, having a key box on our property. I don't want my name listed on the listing. Any kind of things like that. Don't get yourself into a rule violation before you even put the listing on the market. When we've got a way to handle that through Northwest MLS. So any of these 6 bullet points, come to me, we'll show you how to map that out accordingly so you don't get yourself in a bind. Certainly we can do a Form 47. If you're not going to do a listing agreement, that is the proper way to do those types of sales. But by and far, the more listings we have, the more properties that we have on the market, the more exposure we have to our friends in a cooperative environment, the more your clients are going to make. And it's been proven that they will make more money if they list their property with Best Choice Realty rather than doing it off market, especially when we have low inventory across the entire state of Washington right now. So think about that when you're putting paperwork in front of people. I have 2 more things before I wrap up and open it up for Q&A. Prospecting letters are working. So if you're not sending prospecting letters out, and you're trying to look for business, they do work. And we have one right here. We also, I have a buyer that also is working too. And magic letter is what we call that. This is a version of one that you could use. If you are looking for, I don't know how to say this, I don't know how to word it. We have some sales managers that can assist you in knowing what works and what gets responses. I sent out a magic letter a couple months ago, picked up a seller and picked up a buyer from it. So I did have to spend about $400 to mail out to about 400 homes, but it definitely worked and definitely procured more business for me. So letters work, prospecting letters, but you have to be very targeted and you have to be memorable. It can't look scripted. I got a letter. It's funny. We're talking about unrepresented buyers in my own neighborhood. I got a letter on this pretty letterhead, and actually it was pretty funny because it was around St. Patrick's Day, and these buyers who were unrepresented, I won't tell you what culture they're from, but they really want to be in my neighborhood, and so they were door knocking and leaving the luck, kind of like these little coins, along with a handwritten letter. They obviously made copies of it. It was kind of like the magic letter. They took a point from our playbook, and they basically went door knocking to try to see if they can get a property off market, somebody that did not want to use real estate services, probably looking for a for sale by owner, and then for them to find the home themselves. So that's a kind of a truest sense and kind of wraps up our conversation today. But they took a note from our magic letter playbook and literally put like a little, chocolate coin, and was door knocking my entire street trying to look for opportunities for them to actually buy their first home. So very interesting on the magic letter and how personal you can get with it. It does help, and it definitely got noticed by my husband, who brought it in and goes, look what they're doing. They're trying to cut the real estate agent out completely. And it may work and it may not, but I certainly think it's worth a shot if you're looking for business. All right, and then the last slide, just in case you didn't know, here's all of the support information. Our main office number, if you're wanting to get help on anything, you can email your contracts to support@bestchoicerealtywa.com. In Idaho, it's support@bestchoicerealtyid.com. And there's further assistance. You can contact Shannon, Candace, or myself with any questions. So with that, I'll let you guys open up the call. Shannon, do you want to open up the chat? Is there anything?
Yeah. There was one question right off the bat. I wanted to make sure that we could answer it. It says, this may be a duh question, really cute. when a buyer represents themselves, how do they submit an offer? What does the listing broker do in that scenario? They're representing the seller, I'm assuming, in this scenario.
So they're representing themselves on the buyer side?
Buyers representing themselves, how do they actually submit their offer?
Well, I mean, you certainly can get the process started by a buyer, going to, I mean, there's forms out there that they can get themselves. Office Depot, I think at one time when I was an investor, had forms, and that gets it started. But if you're representing the seller and you have obviously forms, you would then counter them with the proper approved forms in the state of Washington that protects the seller. So it's not a dumb question. In fact, that's a very good question. If a buyer submitted something on a napkin, Shannon, like I'm willing to pay $500,000, I'm willing to put down $5,000 earnest money, and I'd like to close on, April 30th. That is an offer. That's on a napkin, but that could still be considered an offer that gets sent to your seller. So then if I was representing the seller in that case, I would take those terms, put them on a purchase and sale agreement, and send that back to the buyer in the form of a counter.
Yeah. Another good question we had. So what if I'm assuming the seller, what if the seller verbally told people at a moving sale, I'm assuming this would work with estate sales, garage sale, that the house will be listed soon, and to come to an open house or keep an eye out for it on the market. So what can I think probably the real question here, Aria, is like, what can we tell our sellers to tell people when people are coming through for those estate sales, garage sales, things like that, when they can notice that the property is going to be on the market soon?
When it kind of going through, yeah, it's a violation of our listing agreement. It says the seller or Best Choice Realty will not pre-market the home. So there is a breach in that part of the contract if you reference our actual listing contract. And that listing contract is the same listing contract that's also listing the statewide forms. So 1A also has that provision of the coming soon and not promoting some property that is it's going to be listing before it's ready to be listed. So the coming soon thing is kind of it's illegal in Washington. It's not illegal in Idaho, which is kind of an interesting difference between the two states. In that case, I would say have your business cards available, at the open house, at the estate sale, just so that if somebody does ask, I have representation, I have contracted with, but that you have a way to contact the actual person that's representing. The worst thing that you can have happen is that seller who is not, is well-intended. They say things that will jeopardize their positioning, where you want to expose the property to the majority amount of people. If they say something in that early, garage sale, it could jeopardize their position when it does hit the market. So
and I'll echo that too. I had a client that was doing an estate sale. It truly was an estate, right? And people come by. It's almost like ambulance chasers in some respects, right? They'll come by and they're trying to lowball. Investors will come by, and so I had business cards that I gave to the owners, and so she was like, there was one or two people that wanted to buy it, and she's like, I don't want to deal with them. I gave them your card, and they can go through you if they wanted. If they wanted more information.
You had the guy call you too, though, Shannon. So to follow up, so to Aria's point, when you called that person again, you didn't violate anything.
Nope.
You basically said, thank you for your interest, but we will be listing the property. And you didn't even tell them when.
Yep. And then, they kind of went down the rabbit hole saying, oh, well, would they take this? And I say, I'm happy to present something if you wanted to write an offer together, but this is the plan is to go on the market. So open it up to as many buyers as possible. Another question we had was the samples for the magic letters. Those are on our marketing center, bcrmarketingcenter.com. You can go ahead and log in there. If you have trouble getting in, just let one of us know. We can make sure we can get a reset password or whatnot out to you guys there too. And then Virginia is just echoing, it's not illegal in Oregon either. So it sounds like Oregon's following Idaho's laws there when it comes to pre-marketing. And then John, did you have a question? It looks like you unmuted your line. So I just want to make sure if you had a question, you can go for it.
No.
Nope, he's all good. Okay. Perfect.
Looks like it's sunny on the other side of the state. It's good.
I know.
I just want to be ready to talk.
Okay.
Perfect. Okay, I think we got all the questions answered, Rochelle. Thank you.
Any other questions, Candace? Anything else that you've heard? Candace and Virginia are fielding a lot of calls. They're sending text messages out with common errors too. So if you get a text message from one of those ladies, it's because we're still seeing a lot of mistakes. So be sure and check that out. Was there something I missed or do we need to cover, Candace?
No, I think everything was good. Thank you for letting everybody know that we are sending out messages. So the message, it's a video recording. It is a legit message from us. And if you guys have any questions or concerns with the brokerage agreement, the buyer brokerage agreement, or your listing agreements and filling those out, please reach out. We definitely want you to be in the know and not in the know at this point. So if it's something you haven't done in a while, that's kind of where it's coming from too. I think there's been a lot of agents that haven't had a transaction since the changes have occurred in January, and now they're happening, which is great. Business is moving. So congratulations, and keep on doing what you're doing. But let's make sure that we dial in, reach out, shoot me a text message, an email if you have any questions on the forms and the Best Choice Realty forms. We want to make sure that everybody gets paid.
Yep. And there's escrow companies that will send commissions back. The escrow companies will get them back from brokerages, and we don't want to be in that position. So call us early. We'll help you through all of that.
Yes.
Well, we'll let you guys go. Have a great week and we'll see you next Monday.